Good afternoon for those who are actually attending from Europe. Good morning from those who are attending from the other side of the ocean. Welcome back to this third day of this workshop. Today we will focus on two specific case studies, which are fundamentally the UK on one hand, and what we could call broadly, as Simi actually does in her chapter, Scandinavian constitutional orders, which covers a bit more of what usually we understand as, strictly geographically speaking, Scandinavian countries. Now, the two speakers today are Professor Martin Loughlin, who is Professor of Public Law at the London School of Economics. I don't think he needs much of a presentation. I think most of us are basically familiar with his work. Was been hugely influential for both public law and constitutional theory during the last few decades. It will represent obviously on the case of the UK. And then we have Simi Larsen, who is a fellow from the Magdalen College, Oxford University. Simi has just published, actually in February, a book on the constitutional theory of the Federation on Oxford University Press. And she is actually currently working on a couple of projects, which seems to be extremely promising. One on the role of the empire in constitutional theory, and the other one fundamentally on varieties of constitutional narratives in Europe. Roberto Toniati, who is a professor at the University of Trento, will be the discussant. And so I would say that given that there is a lot to discuss today, and without much further ado, I will first leave the floor to Martin, please.
Thank you very much indeed, Marco. My assigned topic is to assess the development of the British Constitution as exemplary of the establishmentarian model, one of three pathways that Bruce Ackerman identifies in his project. This presented me with certain difficulties, not the least being that the more I looked at it, the more skeptical I became about the value of the three pathways model. The first half of my paper outlines the three pathways and explains my reservations about it. These include a lack of precision in identifying its key concepts, ambiguities with respect to time sequencing. Most of the narratives, for example, appear to begin only in the post-Second World War period. The lack of engagement with histories of state building rather than constitution making, symptomatic of the general fetish of the times, I suspect, and the rather mixed reception given to his analysis of the revolutionary pathways presented in Richard Albert's edited collection, some of which conclude that far from it being descriptive or analytical, or indeed interpretive, it has a thoroughly normative orientation. So this was the backdrop against which I examined Ackerman's account of the British Constitution as exemplary of a regime constructed by pragmatic insiders, not revolutionary outsiders. Here, in the face of movements for change, the political establishment makes concessions that divide the reformers. Co-opting a group of them, they pass reforming legislation that allows what he calls the sensible outsiders to join the establishment, and this strengthens the established order's claim to legitimacy. This is indeed an analysis around which a narrative about British constitutional development can be presented. Revolutionary Constitutions, the book, includes a short account of his establishmentarian argument with respect to Britain. This identifies as key markers the Reform Act of 1832 and the Parliament Act of 1911, before then focusing on the 2016 Brexit referendum and its consequences. The problem I found with that, even though it's rather short, is that it seems to me to contain too many basic errors to be sustainable as an account. In the paper, I focus for illustration on the question of the use of the referendum. Here, Professor Ackerman falls into the trap of allowing his evident disdain for the result of the 2016 Brexit referendum to cloud his analysis. He explains the referendum outcome, and here I'm quoting, as the product of rabble-rousing efforts to exploit mass prejudices on one side, as against David Cameron, the Prime Minister's, again quoting, sensible effort to renegotiate Britain's deal with Brussels. Now, I doubt that really gets to the heart of the matter. So let's look more closely at his treatment of the referendum in the British system. He regards the 2016 exercise as marking an almost complete break with conventional practice. Whereas its use had been long debated, it was most prominently advocated by Albert Dicey, the high priest of Victorian constitutional orthodoxy. And by 2016, it had been used on 10 occasions. He treats the action of the Conservative government in the 1970s to take the United Kingdom, I'll just call it into the EU as exemplary of normal constitutional practice. Whereas in fact, it brought about a major constitutional change for which controversially, the government had no clear electoral mandate. The Labour Party in opposition recognized this, and they pledged to renegotiate the terms and to put the terms before the electorate, which they did when they went back into power in 1974 and they held a referendum in 1975. Rather than seeing that the Labour Prime Minister, Harold Wilson, was acting in an appropriately democratic manner, Ackerman argues that Wilson was motivated only by short-term problems of coalition management. In fact, Wilson was following conventional practice in seeking a mandate from the people for this major constitutional change. We can employ the parallel with the Parliament Act to justify that, but I'll not explain that now. I think Professor Ackerman also underestimates the pressures that David Cameron was under to hold a referendum on EU membership. It didn't come out of the blue. The Conservative position had been that even the Lisbon Treaty should not have been ratified without a referendum. And they subsequently pledged that there would be no further transfers of competences to the EU without holding a referendum. And that was made law when they got into power in a coalition government in 2010 in the European Union Act of 2011. And yet the Conservatives were still losing support to UKIP. In the European parliamentary elections of that time, the UKIP came top of the poll and the Conservatives had been pushed into third position behind Labour. So it's not surprising that they pledged to hold an in-out referendum on EU membership in their 2015 election manifesto. To say, as Ackerman does, that the referendum was the product of short-term decisions without regard for its long-term constitutional implication, while not wholly inaccurate, fails to do justice to a much more complicated trajectory. He also fails to note that the act that authorizes the referendum was approved, not just by Parliament, it was approved by 90% of the members of Parliament who voted to hold the referendum. Even the leader of the Green Party argued in favor of the referendum, not because she was opposed to the European Union, but because, as she said, she was a Democrat. though of course all these parliamentarians then changed their tune once they saw the result. And finally, Ackerman's analysis of the legal challenge to Article 50 notification intended by the government to be an exercise of prerogative power, which he saw as a self-aggrandizing proposal of the Prime Minister leading to some mind-blowing confrontation in the courts, I'm sorry to say, does not really get to the heart of the issues in that controversy. But the general theme of his short account in the book is that the establishmentarian version of Westminster democracy has been one of the great success stories of the past 2 centuries, but Brexit teaches that it depends on constitutional statesmanship to sustain its legitimacy. Again, I think it's more complicated. The British establishmentarian tradition is the product of an aristocratic settlement of the 18th and 19th centuries, and it has progressively struggled to accommodate itself to the coming of democracy in the 20th century. And I doubt that anyone would say that the 20th century development can be said to have strengthened the legitimacy of Britain's constitutional arrangements. So I come finally to the big question of whether British arrangements exemplify establishmentarianism. If we focus only on the 20th century, the answer seems obvious. But why do we start there? Ackerman actually starts with the Reform Act of 1832. But what if we went back to the 17th century? During the 1640s, England was racked by civil war, leading to the execution of the king in 1649. Revolutionary times, time 1. Under the charismatic leadership of Cromwell, a constitution of the Commonwealth was drafted in 1653, time 2. Cromwell dies in 1658, creating a legitimacy vacuum, time 3. In 1660, the result is, well, it's certainly not judicial supremacy. The result is the restoration of the monarchy in the figure of Charles II, time 4. And the cycle begins again. During the 1660s, there's an attempt to rebuild charismatic authority around the figure of the king, time 1. This gets routinized through the restored authority of the ancient constitution, time 2. Charles II dies in 1685, leading to a crisis of legitimacy because his brother, James II, is a Catholic with modernizing intentions on absolutist lines, time 3. In 1688, we don't get the consolidation of constitutional authority, but the overthrow of James II by the Whig aristocracy with the assistance of William of Orange, time 4. 1688, revolutionary change, time 1. Now, I could go on. The general point I'm trying to make is that where we end up depends on where we start. Professor Ackerman might say that his exercise is purely a 20th century pathway, though, as I've mentioned, it would be much more accurate to say that it's the trajectory of the latter half of the 20th century. And in that case, the trajectory may not be a distinguishing feature at all of revolutionary constitutions. The path to time 4 judicial supremacy over the last 50 years can also run from establishment and elite narratives. It's a feature of what I call, in a book soon to be published, the age of constitutionalism. However, the basic problem with claiming that it is a 20th century narrative is that Ackerman concludes revolutionary constitutions with a chapter on the United States. His objective is to show that the American narrative is not exceptional and that other countries are traveling down the very same Enlightenment pathway. The difficulty he has is that if the United States is exemplary of a revolutionary constitution because of events in the late 18th century, then why isn't the English story from the 17th century not also illustrative of the forging of a constitution from revolutionary origins? And if, starting from more recent times, England, Britain, follows the establishment pathway, then surely so too does the United States. Once we see that the United Kingdom was once revolutionary, becomes elite, and is now establishmentarian, can we not see a similar trajectory in American development? The United States was once a revolutionary constitution, but it quickly became elite and is now establishmentarian. If we survey the development of the United States Constitution, not from its founding, but from the beginning of the 20th century, then as Ackerman's frustrations with FDR's failure to entrench a new constitutional settlement shows, the trajectory is anything but revolutionary. Since then, since the beginning of the 20th century, the American Constitution has been amended only 12 times, mostly in relatively unimportant ways, and it's now regarded as being pretty much fixed. If we are seeking a paradigmatic example of establishmentarianism, it's not Britain, it's the United States. Once examined in detail, Ackerman's ambitious study charting the rise of world constitutionalism begins to look like a project in which the results have been determined by the framework imposed. But what it vindicates, malgré lui, is that there may be three pathways, but they're all heading in a single endpoint: judicial supremacy. And this is an argument that I think is corroborated by Sina Larsson's excellent paper, which is presented next. Many would say that's a good thing, but I would reply, beware of what you wish for. And this is why my forthcoming book is called Against Constitutionalism. And on that note, I will end. Thank you.
Martin, thanks a lot. Signe, your turn, please.
Okay. I'll try to share my screen. Does it look okay?
Yes, we can see it.
You can see it. And you can see like the whole not.
Yes.
Yes, good. Okay.
Perfect.
Okay, so I want to start by thanking Marco and Augustin for inviting me to this wonderful conference. It's a great honor and a pleasure to speak here today. And my assigned task was to talk and speak about the pathways to constitutionalism in Scandinavia. And when I was writing this paper, I realized that if I was to provide an answer to the question of whether and to what extent the establishment ideal type can help us make sense of the Scandinavian regimes, I had to go back in history at least a few centuries. And what I've done in the paper is to trace the emergence and development of constitutionalism in Scandinavia as a region from the decline of the Scandinavian empires in the 18th and the 19th centuries, or the rise of modern majoritarian democratic regimes in the short 20th century, and to the transformation of these regimes in important part due to European integration and rights-based constitutionalism. And there are quite a lot of historical details in the paper, which I, in the interest of time, largely not will go into in this presentation. What I will do is to present my general conclusions regarding whether and to what extent we can think about Scandinavian constitutionalism, if such a thing can be said to exist, based on the establishment pathway to constitutionalism. But I'm of course happy to speak to the individual Scandinavian countries in the discussion afterwards to the best of my ability. So before I go into some of the details and reasons for why the historical developments of the Scandinavian constitutional regimes differ both from each other, but potentially also from the establishment ideal type, I want to point to a clear and obvious similarity between the Scandinavian constitutional regimes and the UK that makes it intuitively attractive to include Scandinavian constitutionalism at large in the establishment ideal type. The Scandinavian countries, as well as the UK, are characterized by strong constitutional government, but weak constitutionalism. And what I mean by this is that the Scandinavian countries are all characterized by robust constitutional regimes with low corruption, strong protection of rule of law, high public trust, and strong and consistent political participation. And somewhat in contrast to the UK, they are also the strongest welfare states and most socially equal societies in the world. The written constitutions have, however, only played a minor role in the development of the 20th century Scandinavian constitutional regimes. Constitutional norms and constitutional amendments have been relatively insignificant for the political and social developments of the modern democratic constitutional regimes in Scandinavia. And Sweden is the most extreme example where references to the written constitution and constitutional norms in public debate after the Second World War were looked upon as almost silly. The idea that a written constitution interpreted by a court ultimately should be able to overrule the sovereign will of the people as expressed in parliament is still highly controversial in Scandinavia. So for that reason, Scandinavia has been described as the final frontier against the rise of juristocracy. So this all sounds like a promising start to include the Scandinavian countries in the establishment category. And that is to say, it does not sound all too far from the British case. And setting aside Martin's objection, at least for the sake of argument for now, my sense is that the establishment pathway, at least in part, can help us make sense of the Scandinavian constitutional regimes and the constitutional histories. But that being said, I think the establishment ideal type is more helpful in terms of explaining some constitutional developments in some countries than others, and perhaps it's more fitting for certain historical periods than others. So in that way, I think I'm seconding Martin's point from before. So I will now go through the paper in as much detail as time allows. I'll try to give you an overview of the pathways to constitutionalism in Scandinavia, and I'll raise some questions regarding the extent to which the constitutional developments of the Scandinavian countries can be explained by the establishment ideal type. So let's start with some geography. Let's see if I can take the next slide. Yeah, here we are. So in a narrow and precise sense, Scandinavia refers to Sweden, Denmark, and Norway. And these countries have an incredibly strong affinity in terms of history, politics, culture, and language. But as a broader term, Scandinavia also includes Finland, Iceland, and the Faroe Islands. And all these countries have a shared and overlapping political history that dates back to the Kalmar Union. And when the Kalmar Union fell apart in 1523, it gave rise to two rival Scandinavian empires. So the Swedish Empire in the east included not only present-day Finland, but most of the Baltic region and a few overseas colonies in West Africa and the West and the Americas. And Western Scandinavia was governed by Denmark-Norway. This was a multinational real union, including the duchies of Schleswig and Holstein, and a number of overseas possessions, so Greenland, Iceland, the Faroe Islands, Danish India, the Danish West Indies, and the Danish Gold Coast. And the origins of constitutionalism in Scandinavia is to be found in the decline and disintegration of these empires. So demands for constitutionalism started to emerge both at the center and at the periphery in moments of imperial weakness. So modern constitutionalism, and I stress modern, in Scandinavia emerged first in Sweden in the 18th century. So in moments of political weakness due to imperial decline, the king agreed to share power with the estates in order to bring about moderate outsiders and thereby avoid a full-scale revolution. So in that sense, early Swedish constitutionalism fits the ideal type of establishment constitutionalism rather well. with the exception of Iceland, that I guess is the best case for revolutionary constitutionalism in Scandinavia. It is less clear-cut whether the rest of the Scandinavian countries belong to establishment constitutionalism, revolutionary constitutionalism, a hybrid form, or something else entirely. So the pathway to constitutionalism in Finland begins with the Swedish defeat in the Finnish War, which is part of the Napoleonic Wars in the early 19th century. So after the war, a third of the territory of the Swedish Empire is ceded to the Russian Empire, where it's constituted as a constitutionally autonomous entity, which is the Grand Duchy of Finland, which is governed under the fundamental laws of the Swedish Empire, such as the 1772 Instrument of Government. But throughout the 19th century, the Finns, they managed to rely on these fundamental laws that they have inherited from the Swedish Empire to resist the imperial authority of the Russian Empire. So in moments of weakness of the Russian Empire, the Finns managed to secure concessions that lead to the emergence of something akin to establishment constitutionalism in Finland. But the Finnish War also had internal constitutional implications for Sweden, because the loss of the Finnish War led to the 1809 revolution, or coup d'etat. It's known in both ways, where the Swedish king was deposed and a set of new fundamental laws were introduced. Importantly, the 1809 Instrument of Government that remained in place until it was finally replaced in 1974. So Norway is in some way a similar case to Finland. So after the involuntary breakup of Denmark-Norway after the Napoleonic Wars, Norway declared itself independent and it gave itself a constitution. And here we have a picture from the Norwegian Constitutional Convention. But it's actually not really clear-cut whether Norway belongs to the revolutionary ideal type. So for significant parts of the Norwegian elites, independence and the constitutions were created and declared in an attempt to resist the incorporation of Norway into the Swedish Empire. The independence movement was led by the most insider of all insiders, namely the Crown Prince of Denmark-Norway, who was also the resident Viceroy of Norway, in a failed attempt to sort of return Norway to the heart of the Danish Empire, the Danish-Norwegian Empire, and importantly, keep the Norwegian colonies. But that failed. So there was a short war of independence, and after that, Norway was subjected to the Swedish crown under what now became the United Kingdom of Sweden and Norway, where there was a compromise struck, and Norway was allowed to keep its constitution under this new United Kingdom. So this was actually a concession from the Swedish king that Norway was allowed to keep its constitution. So it was in order to bring aboard sort of moderate outsiders in Norway. So the question is, was Norway revolutionary, or was the constitution a contract between the people and the king? To my astonishment and interest, that was actually contested for the first 70 years of Norwegian constitutional history. The nature of the constitution was contested, and so was the subject of the constituent power. In the end, the question was settled in a highly politicized court case in 1884, where the Norwegian Court of Impeachment declared that the royal veto on constitutional amendments was unconstitutional. So Norway was revolutionary, it was decided. And Norway is in this way sort of distinct from the other Scandinavian countries because it has its own tradition of judicial review. But whether judicial review is sort of a product of a revolutionary heritage, or whether it's better understood as a means of restraining democratic and progressive politics after the monarchical principle was finally defeated, remains contested. What is clear is that the constitutional developments of Norway in the 20th century, they're not really radically different from those of the other Scandinavian countries. So what is important to take note of is that with the rise of social democracy, judicial review was largely kept politically insignificant, even though the attempts to abolish it altogether, they failed. Okay. So with the defeat of Denmark-Norway in the Napoleonic Wars, demands for constitutional governments started to emerge also in other places of the now formerly Danish realm, importantly in the southern duchies, that in part also were included in the German Confederation. And Denmark is a really messy, difficult case. So Danish historians disagree on whether the emergence of constitutionalism was a product of a revolution or whether it's better explained as a counter-revolutionary instrument. And thereby sort of closer to the establishment ideal type. And this assessment depends on whether the broader imperial context is taken into account or not. My sense is that ultimately Denmark is closer to the establishment ideal type, because the 1849 constitution in many ways was a concession to moderate outsiders in the metropole in order to avoid a full-scale revolution in the metropole that again would weaken the imperial control of the duchies that remained under autocratic rule. So to sum up, it's not clear-cut whether the emergence of constitutionalism in the individual Scandinavian countries sort of is a product of evolutionary constitutionalism or whether it's in some sense closer to the revolutionary ideal type. And this assessment in large part depends on whether the events in other parts of the empire is taken into account or not, and whether concrete events are interpreted as revolutionary in nature or not. I'll now turn to the second part of my paper that discusses the constitutional developments in the 20th century. So in the short 20th century, the Scandinavian countries have in some sense followed the script of the establishment pathway, because it evolved through landmark reforms and ordinary legislation. But that being said, I don't think that it's entirely clear that the 20th century Scandinavian constitutional developments sort of are a form of establishment constitutionalism. And the reason for that is the hegemonic role played by the social democratic parties. So because the social democratic parties, largely in alliance with peasants and farmers, managed to take over the control of the apparatus of the state for most of the short 20th century, the reform programs are based on class compromise rather than extractions from an old elite. And in contrast to the UK, the old elite did not manage to stay in power for any significant period of time in Scandinavia during the short 20th century. So this means that in contrast, not just to the UK, but the rest of Western Europe, both the interwar period and the post-Second World War reconstruction in Scandinavia, they were driven by the left and not by the right. And my sense is that the main reason that the parliamentary systems not only survived, but thrived in Scandinavia after the introduction of the broad political reforms in the beginning of the 20th century is that this system suited the social democratic parties. So based on class alliance and class compromise, they were capable of taking control of the apparatus of the state and employ it to create a radically new form of society based on social and political equality. The political developments in Scandinavia in the short 20th century are shaped by broad compromises initially struck in the interwar period. But these compromises remain, and these compromises, they remain the foundations, not just of the welfare states, but also the modern democratic political regimes. But they have never been granted a formal constitutional status. So in all the Scandinavian countries, the constitutional regimes were fundamentally transformed in the early 20th century with the rise of majoritarian democratic regimes. But this fundamental constitutional transformation was not necessarily reflected by any significant changes to the written constitutions. So Sweden is the most extreme example where constitutional praxis was divorced from the written constitution to the extent that the period between the first democratic elections in the 1920s and the new instrument of government of 1974 is now known as a constitutionless half century. And the core argument of my paper is that all the Scandinavian countries are characterized by an emerging gap between the formal and the material constitutions in the 20th century. The constitutional regimes have largely developed alongside the written constitutions by circumventing them or by simply ignoring them. So throughout the 20th century, the constitutional regimes, they are alive and well, but the written texts are slowly dying and becoming obsolete. And for that reason, I think it's difficult to think of Scandinavian constitutionalism as a form of living constitutionalism, because in contrast to common law countries, there's no institution that can sort of breathe new life into the written constitution. Courts cannot work as ventilators for the Constitution, and the Constitution cannot be put on life support. This is the words of like one of the Swedish lawyers writing about this. And this is a significant difference, I think, perhaps to the establishment ideal type that is largely modeled on common law countries as far as I can see. So in Scandinavia, judges do not take on the role of clarifying, and I quote, an evolving tradition of elite rule by proposing insightful ways of modifying historical precedents in light of current challenges. In conclusion, because of the emerging gap between formal and material constitutions in Scandinavia, the formal constitutional reforms in the 20th century have played a very peculiar role of sort of attempting to close a gap between norm and reality. The reforms have not so much been instruments of change, but rather projects of constitutional modernization and codification. But these projects are not yet done, and they're not finished, because European integration has led to a fundamental transformation of the Scandinavian constitutional regimes by introducing what I, in the third part of the paper, call constitutionalism by proxy. And this manifests itself, for example, in the form of an emergent practice of judicial review and fundamental rights jurisprudence, as well as other significant institutional reconfigurations, such as the establishment of central bank independence. The constitutional significance of European integration is, however, not formally reflected in any of the Scandinavian written constitutions. And there's therefore an argument to be made that the Scandinavian countries have entered a new constitutionalist era. And we can return to this in the discussion if you like. So thank you very much. This is all I had to say.
Thanks a lot, Signe, for this really rich and insightful presentation. Now, the floor is to Professor Roberto Toniati, who is this discussion of the two papers. Yes, Roberto, the floor is yours.
Yes, thank you very much, Marco. And let me take full advantage of the few minutes which I'm given. The discussion of this third session basically deals with methodological as well as substantive aspects of the construction by Bruce Ackerman of the second of the three distinct pathways that, according to their own features and time segments, are to be regarded as sources of legitimacy of the constitutional orders established in Europe. Let me add just a word on the naming used by Bruce Ackerman, as the point will come on later, in particular after yesterday's papers and discussion, and it is the name of revolutionary pathways. I'm afraid of how what I consider radically and authentic revolutionary regimes might be dealt with a possible fourth volume. For instance, the Bolshevik Revolution of 1917, that originally found in itself the only cause of legitimacy, that made a complete tabula rasa of the previous normative setting, abolishing rather than formally repealing all the codes and legislation then in force, and administering adjudication through popular tribunals composed by members of the working class, not trained in law, that were tasked with the deciding cases and controversies without any written rule, but only in the best interest of the proletariat, as they were able to interpret it. Not to speak of the Cultural Revolution in China in the 90s of last century. Now, Bruce is well aware of the gap between what he names revolutionary pathways and other historical pathways that are likely to be more objectively revolutionary. And in fact, he admits that he deals with revolutions on a human scale that do not attempt a total makeover of society. I think that the consolidation of the labor revolutionary as applied to the countries that are presently included in it will not be an easy cultural and scientific process. and I myself would be quite reluctant to propose it to my students. But more specifically, dealing today as we are with what Bruce names as the establishment pathway, which is the outcome of the comparative analysis of a number of countries that will be taken care of analytically in the second volume of the trilogy. So today, short of the book, we are trying to achieve our purpose this afternoon through two excellent papers. The first by Martin Laughlin and the second by Stine Reiling Larsen. The two papers are extremely interesting, and both of them offer quite a bit of food for thought, both on the ideal type specifically dealt with by Professor Ackerman, as well as more analytically on the suitability of the UK and of Scandinavian countries to fit into the ideal type itself. By the way, I would like to strongly recommend reading Stine Larsen's paper, as it gives a fascinating and synthetic overview of Scandinavian or Nordic constitutionalism, which does indeed have its own distinguishing features, as Signe's paper today fully confirms. I have read about Scandinavian constitutionalism here and there, and I'm ashamed to say that I have never made of it my priority in research. I think that for a comparative constitutional law researchers, elaborating more on within infra-European constitutional models would turn out to be a very promising endeavor. Also, in order to find out some similarities between British and Scandinavian constitutionalism. Now, a few preliminary words on the comparative method, and more specifically on Martin Laughlin's paper and his expression of skepticism on it, as well on the use made by Professor Ackerman of it. Quoting Günther Frankenberg, Martin refers to constitutional texts as a second-order phenomenon if unaccompanied by the examination of broader developments in state and society. I do agree with him to a very large extent. In fact, the goal of the comparative method is to identify the rules that are actually regulating social and political phenomena and deserve to be compared whether similar or not, because the comparative method is an instrument for focusing the respective rationale. Quite seldom such rules are those written in positive law, as Martin suggests, even less in the text of a written constitution that is constantly challenged in practice because its main object, that is the regulation of political power, may be stronger and more effective. It is not an easy task to try to subordinate the exercise of political power to the law. Now, this fact explains the success of judicial review on the administration, as well as in so many cases in continental Europe on legislation as well. Nevertheless, the text of constitutions as the outcome of constituent assemblies and citizens' vote to ratify it still are an interesting source for understanding, if not the law actually in force, how that polity, that means citizens and civil society and the political system, think of themselves, attempts at giving it their own portrait, elaborates a sort of authentic and somehow orthodox family picture. The example is provided by the constitutional text of most, if not all, of Central and Eastern countries, and even more Southeastern countries, Southeastern European countries, with the express adoption of European standards in the form of government as well as in protection of fundamental rights. Let me just mention very briefly Article 1 of the Constitution of Serbia, which states its commitment to European principles and values without any further specification. In such more limited perspective, the contribution by the written constitutional text to understanding the very pathway followed by an individual jurisdiction or even by a regional group of jurisdictions would be very instructive and significant, even more than Bruce Ackerman is inclined to recognize. So in the long run, however, taking into account these remarks, I think that Martin is generally right. I would still add that perhaps he fails to acknowledge that in fact more and more the method of comparative analysis is carried on in a contextual framework and is not limited to the perusal of text. And in fact, this is indeed the method followed by Bruce Ackerman, who does not pay too much attention to constitutional text, to the extent, as I said in the initial panel on Monday, that I'm afraid that in the book there is too much context and too little law. We do not have the second volume yet, and therefore we cannot really assess how the comparative method is employed in the construction of the establishmentarian pathway ideal type. Neither are we able to fully and adequately assess how appropriate the choice of the concept and word establishmentarian is. For the reasons I'll expose later, I don't think it is fully. Yesterday, we heard both support and criticism of the method as well as of the substantive features of the revolutionary model. And the same happened today with the two papers presented. In fact, we had more of critical criticism, as it were, than full support with regard to the architecture of establishmentarian pathways. But let us consider some characters of this ideal type. The establishment pathway ideal type is perceived as an engine of legitimation or a developmental dynamic corresponding to a political order built by pragmatic insiders than by revolutionary outsiders. In this way, constitutionalism arises through landmark reforms rather than revolutionary ruptures. Now, I think that even though we may not agree on the qualification of establishmentarian ideal types, it is indeed well-founded, I would say, that what the constitutional setting of the UK and of Scandinavian countries have in common is quite interesting and quite fascinating. I refer to a firm and strong confidence mainly in the political process. Consequentially, just as firm and strong a confidence in Parliament as the institution faithfully transforming that confidence into effective public policies and legislation, rather than in a set of constitutional social rights, as we continental Europeans are inclined to do. And still a lower confidence in juristocracy as a proper way of finding a solution to any problem having a high political potential, and for which lower confidence in juristocracy, I mean, for which, according to the postulates of legal theory of civil law countries, there must be a judicial solution to be found, not in the law of the land, but in the penumbra of written law, according to the principle of non-liquid. From this point of view, I would add the political question doctrine of the US Supreme Court, which is not part of the heritage of civil law countries. And I would also add the legal culture of Ireland, at least as expressed by Article 45, which states that principles of social policy do not give origin to justiciable social rights. So there are historical reasons for this. At least in the 20th century, the political system of these countries has not generated from within an important autocratic ideology, and even less an autocratic regime, whether it is fascism or national socialism or scientific communism or Marxism, Leninism. This is why the same countries, both the UK and Scandinavian countries, have not had at some time in history the pressure to introduce judicial review of legislation. And I would consider just as significant, they didn't even have the need to go as far as the Constitution of the Netherlands, that in Article 120 expressly states that the constitutionality of acts of parliament and treaties shall not be reviewed by the court. The judicial declaration of incompatibility by British judges with reference to the European Convention of Human Rights and the case law of the European Court of Human Rights under the Human Rights Act of 1998 has somehow altered or threatened to alter a balance of function and of powers that has been constantly present in the system. From this point of view, the codification of the status of certainly the European Convention of Human Rights in the constitution of Scandinavian countries is very significant. And I would say also that at least some countries, Denmark and Finland in particular, have introduced very strict control on the government's dealing with the affairs of the European Union. So I would say that here, the pathway of legitimacy does not work in support of the Constitution by itself, unless we adopt a different definition of Constitution and a different framework for locating this definition. Now, in the case of the United Kingdom, I would say that it is the law of the Constitution of Dicey, inclusive of common law rules such as the royal prerogative, of statutory sources in constitutional matters, of conventions of the Constitution in parliamentary practices and customs. Both in the United Kingdom and in Scandinavian countries, reference as a source of legitimacy is rather to be found in a shared and wide sort of pre-constitutional understanding, in a Weltanschauung or worldview with regard to values and reasonable expectations concerning the way as well as the what government ought to do. It is a sort of functional equivalent to a written constitution. And as I said earlier, joining the European Union and European Convention of Human Rights has entailed to some extent a shift in a fundamental paradigm, at least with the United Kingdom, that has ultimately the United Kingdom rejected through Brexit. And at an early stage, it seemed such rejection to include also withdrawal from the European Convention of Human Rights and to rewrite a Bill of Rights of the United Kingdom. Now, this condition seems to me to be and to work more as a source of legitimation of the state rather than of the Constitution. In other words, a shared worldview that historically was not denied by the institutions that continue to deserve the confidence by citizens. And yet, the Scandinavian countries do have entrenched constitutions. They do not have eternity clauses, with the exception of Norway, which has, if you like, almost, let's say, almost a naive eternity clause, when it states that such an amendment must never, however, contradict the principles embodied in this constitution, but solely relate to modification of particular provisions which do not alter the spirit of the Constitution. Now, the spirit of the Constitution, of course, is very vague, but at least it is suitable to be interpreted by the parliament that is going through that amending process. So that
could you wrap it up in 2 or 3 minutes, please?
Absolutely. I want to go through a number of, let's say, concessions that Scandinavian countries do allow to constitutionalism. In particular, Finland, for instance, which for a while practiced and then at some stage formalized the enactment of a limited derogation of the constitution, which was what in German they call Durchbrechung, or rupture of the constitution. And again, in Finland also, there is a parliamentary constitutional committee that shall issue statements on the constitutionality of legislative proposals. So in other words, there are some concessions to constitutionalism, although I would say that the overall picture is the one that has been described so far and so well by the paper. Let me just say that perhaps we are in front of a sort of confirmative constitutionalism rather than transformative constitutionalism. In other words, a constitutionalism that confirms the achievement, past and present and perhaps future, of the political process. All right, I think I'll stop here. Thank you, Marco, and thank you all.
Thanks to you, Roberto, for these really, really engaging comments. Now, so we will give to Bruce now the possibility of reacting, and then Martin and Signe will have the floor for reacting to the discussant and to Bruce's comments, actually. Bruce, right. The floor is yours.
Well, thank you very much. First on the methods, I want to emphasize my agreement with Roberto that in contrast to I suppose to be another real leader in comparative constitutional law, Tom Ginsburg, I am not a person who focuses on the written text as if that's what the Constitution is. To the contrary, as Roberto emphasizes, maybe to a fault, that's his problem, but he emphasizes that what I'm talking about is something like what Thomas Kuhn talks about, a paradigm of legitimacy. When we engage in if there's a scientific community, there is a paradigm of what good science in medicine is. If someone doesn't fulfill the paradigm, he might be right objectively, but he isn't being scientific. Then there are scientific revolutions. Then there are adaptations within the paradigm. Also, to return now to Martin, of course, Martin, I do think, maybe I'll even send this around. I gave a recent lecture in the Juris North series, which generated the normals. One thing that you can't say about me is that I'm bland. It's the normal reactions of huh, what, etc., and so forth. You're wrong. On the what I call the Johnsonian revolution, meaning not meaning the current incumbent. You're absolutely right. This brief discussion is simply. I don't want to. It has to be complicated in a host of ways, which I intend to do. And indeed, one of the reasons that Volume 2 has been postponed is I wanted to see how Brexit worked out before I started shooting off my mouth. And you're also right, Gordon, that the three pathways, or whatever number there are, and however they're best conceived, I do not intend to be only addressed to the post-Second World War experience. And I entirely endorse your discussion of the Cromwellian revolutions, et cetera, and so forth. Absolutely, these are general legitimacy problems. If you're an outsider, or if you are an insider trying to adapt to the outsiders, et cetera, and so forth. These are general problems of legitimation. And I do not want to say that they are solved successfully. To the contrary, they're often failed. So I think that there's less, I mean, there's probably disagreement. I don't want to minimize it, but there's a good deal less disagreement both for Roberto and for Martin than appears. I do emphatically want to emphasize that judicial review is not a necessary condition for constitutionalism as my definition has it. My definition, to put it in Senior's terms, the short 20th century constitution of the Scandinavian countries, let's just keep it at that, is not constitutionalist in my definition of the term. There is no constraint, institutional constraint, on the exercise of majority will in the parliament. That's not constitutional. It might be a good thing, but that's not constitutional. So for example, just to give an example, in the UK, the Bank of England is a constraint on the power of the Prime Minister. It has been for a long time. Therefore, that's a constitutional constraint on prime ministerial cabinet government. So there we have, and that has nothing to do with judicial review. How did that happen? Through establishmentarian adaptation would be my thesis. So if we look over the course of the 20th century. But that could be wrong. All right. Now, what I do want to emphasize, to show Martin's point, and also to make the main methodological point for this seminar, that we have to take a European point of view. I would like to I would like to begin and also to make Martin's point about how these models actually apply. I mean, the reason why I did it for the post-20th, post-war period is because I didn't want to be that ambitious. It's an ambitious enough book to compare India with South Africa in the post-20th century, in the post-war period. Maybe I'll stick around long enough, I profoundly doubt it, that I could do something as Hegelian, although I'm not Hegelian, as that, as what you're suggesting, but perhaps other people will take up this task and I would love it. But I want to begin with 1848 and in the context of the fundamental thought that is being generated by these discussions in my mind, which is that the country by country approach that is being taken is not taking into account the European realities that are at the foundation of many country by country developments. So to put it yesterday, for example, we cannot talk about Portugal. I thought it was a great paper, without talking about Spain. You cannot actually understand how they're of course operating under different pathways, say Bruce Ackerman, but you have to talk about both in order to understand how they get and why they get and when they get into the European Union. And how they're dependent on one another. But what I want to talk about here is 1848, the Frankfurter assemble is this revolutionary event generated by, of all things, Scandinavian imperialism. Generating a war which corresponds with the 1848 popular revolution expressed paradigmatically in Frankfurt in the Paulskirche, which elaborates a constitution for the German people, as it was stated. And of course, what happens is that the Prussian king stops the war and crushes the Frankfurter Assembly, leading to a very fundamental parallel between Italy and Scandinavia. In both cases, there's the Statuto what's the year? 1850? I forget I'm sorry.
Italy,
There's a
1848.
48, right? There's a Statuto, which is a flexible constitution for an entity called the monarchy, which has almost no substance. What is this monarch of? It's at least in Scandinavia, there really is a monarchy. When we have also a flexible constitution. Why does the history of the two countries diverge so much? One fundamental answer is the Roman Catholic Church. The Scandinavians are not Catholics. And they don't have to engage in the great struggle of the 19th century. Let's shift to Europe, to Italy. I'm just doing Italy, etc. No, in 1870, what is 1870? The Pope is the prisoner of the Vatican. The Pope is the leading force of anti-enlightenment with a capital E, French Revolution. This paradoxically, I want to question the top-down state building of Marcos yesterday, because since the Pope will excommunicate any person who serves in the government of the reunited Italy, the king has no choice. He has to depend on the secular. He has to. Now, to be sure, with the De Gasperi in 1912 or so, sorry, in 1912, De Gasperi is the Pope isn't excommunicating you anymore, and so De Gasperi in Turin establishes the first. He doesn't call it Christian Democratic Party. And there is the First World War. Afterwards, he is the last Christian Democratic, I'm not going to keep on changing the names. He's the last representative of the Christian Democratic Party who is expelled by Mussolini. And what does he do? He does the same thing as Toniati He runs and wants to leave the country and lead the revolution from outside the country. He is an enlightened revolutionary, a Christian democratic Enlightenment revolutionary. Just as Toniati is a communist revolutionary. The only difference is that he is caught at the railroad station as he's leaving and thrown into confinement and almost dies. This person is a revolutionary and has a responsible Enlightenment revolutionary. He is very similar to Nelson Mandela. But notice, in Scandinavia, nothing like this is happening. There is actually a consensus on social democracy. There is no consensus in Italy. There is fundamental struggle between principles. Now, it is here where I really want to emphasize something terribly important. This is what democracy is always about. I reject the thought yesterday of Marco's, and here we do have a disagreement, I think. I think it's an excellent paper, don't get me wrong, but I really, this one, I think that we just have a fundamental disagreement. Should we have a liberal capitalist, classical liberal capitalist democracy? Should we have a social democratic democracy? Should we have a consociational democracy where labor and capital are on the governing boards? Let's just take these three: consociationalism, liberalism, social democracy. Now, I happen to be a social democrat. Now, of course, there's an argument within the Church of Social Democrats. What is the right way, et cetera, and so forth. What Senia is saying is, so the only group that was dominant in Scandinavia in the 20th century were the Social Democrats, who argue among themselves. This is very atypical. What democracy is about is precisely that people disagree and the majority win until they lose. So the fact that Berlusconi is a revolutionary. Not my favorite revolution. Right? And what is he doing? He's, the 2006 referendum, which is defeated, is fascinatingly similar to the scam election of 1951. Both Berlusconi, who is, now this goes back, by the way, to Martin, is there a revolution? Ronald Reagan is a revolutionary. He stands for the proposition that government is the problem, not the solution. Barry Goldwater in 1964 was a revolutionary, and he lost, crushed by Lyndon Johnson. The fact that Berlusconi loses doesn't mean that we are not in a period of self-conscious constitutional crisis. Now, it's certainly true when we go backwards to the 1970s and 1980s. We have, with some communist struggles on the periphery, we have actually a moment of general agreement between the Christian Democrats and the socialist, and we had something that for a very short time looked like Scandinavia, even though it wasn't. Because Christian democracy is, on the one hand, not strongly capitalist, but on the other hand, it's Christian in the papist sense, and that's a feature that they haven't been able to struggle with. However, what we're now struggling with in Italy is a constitutional crisis in which the court isn't playing very much of a role. However, and it is of course significant that the only legitimate forms of a reconciliation in this conflicting ideological struggle is our central bankers, Draghi. But that doesn't mean that it isn't you have a definition of constitutionalism so that it has to include more and more people into it and give them more and more social rights. That's a social democratic conception of constitutionalism, which I'm in favor of. But that is not what I am trying to do in this book. With, apologies to Martin Laughlin, I am not trying to be an apologist for the American system. To the contrary, I am trying to discuss and analyze different modes of constitutional legitimation, which would also apply in the context, as Senia is suggesting, in empire. I think that I've said enough, but I hope that this will encourage discussion.
It will, for sure. Now, Martin, your turn to react, and then Senia.
Okay, I shall try to be very brief. Let me just make 2 or 3 observations. First, comparative method raised by both Roberto and Bruce. Let me emphasize, I start out my paper by saying I have been reading Bruce Ackerman's work for decades and with tremendous admiration. His account of the historical development of American constitutional law is entirely admirable. What is really important about it is its focus on regime rather than some formal constitutional text. Now, the problem I have is that I accept that entirely, and that would be the approach that I would take to comparative analysis. The problem about a regime-based approach to comparative analysis is that it opens up the question of what comparative constitutional law is actually seeking to study. Is the Constitution a text that seeks to provide an instrument of government, a set of rules by which the exercise of governmental power is to be controlled, or is the Constitution actually a symbol of collective political identity? And if it's as it increasingly seems to be becoming, an entity like the latter, then studying the regime of any country is incredibly difficult. I spent my life trying to understand the British Constitution, and I don't really think I've got my head around it. As Woody Allen once said, how can I understand the universe when I can't work my way around Chinatown? And it's that problem that I think one has to face if, like Bruce Ackerman, I have a regime approach to the issue. All of the terms that we use in constitutional law mean quite different things in different regimes. And it's seductive to think that when we talk about the British Parliament, we mean something similar to the French National Assembly or whatever. These are the wrong places to start. So I think actually if you have a regime approach, it's almost impossible to do comparative analysis on the scale that Bruce is intending to do. That's my first point. Let me illustrate that. Bruce says Reagan was a revolutionary, and I assume he's therefore saying America is still a revolutionary constitutional tradition. Well, I would say Thatcher was a bigger revolutionary for the British system than Reagan was for the American. Thatcher actually brought about a fundamental revolution in the system of British government. Through 4 terms of conservative administration, we restructured the welfare state, we privatized, nationalized industries, we instituted market systems through all of our public sector processes. We brought about a governmental revolution. And so the British, therefore, is part of the revolutionary tradition if one takes a regime approach. So it opens up very difficult methodological questions if, as I do, I share that contextual approach to the studying of this subject. Second or third point, and then I will conclude. Well, perhaps I can tie a point that Roberto makes about the impact of withdrawal of Britain's withdrawal from the European Union, the impact on the Council of Europe and European Convention, and what that implies with the question that the difficult question Renata has posed on the chat box. If I can paraphrase it, what forces are shaping constitutional normalization in contemporary the British system? Who are the key protagonists? Well, first, Brexit has further unsettled an already unsettled constitutional arrangement. There are hardly any forces for constitutional normalization. And that is reinforced by the pandemic. But the big constitutional questions that were thrown up as a consequence of Brexit are territorial. It's not a question of what our constitution is, it's a question of what our state is. We now have a situation of considerable unsettlement in this complex multinational entity we call the United Kingdom of Great Britain and Northern Ireland, where the Scots, of course, are pushing for another independence referendum. Northern Ireland is unsettled once again because of the terms of the Brexit withdrawal agreement, the fudge over the Brexit withdrawal agreement. And so we have a situation where we hardly have any forces of normalization. Everyone's asking everyone who's trying to push the question is asking, what is the nature of our state, not our constitution? Because we can only talk about constitution once we already have a sense of who we are as a people, and who are the people who are consenting to the rules that under which we are governed. And Renata asked, do lawyers play a key role? Well, yes, lawyers have been playing a key role, and this ties to Roberto's point about rejection of the European Union maybe leading to Britain's withdrawal from the European Convention on Human Rights. There's a lot of discussion in the Conservative Party about the latter, but I don't think this is going to happen. And in any case, what has happened is that over the last 30 years or so, our judiciary have developed a rights-based approach to the review of public law questions. Even if the government withdraws from these formal mechanisms, our courts are not going to change their mindset. They are going to continue to adopt a rights-based process of judicial review. The government will try to cut back on that by specific legislation, but there will be strict structural limits to the way in which, through legislation, one can limit that power of judicial review without provoking yet another crisis. So I think once we've moved down that trajectory of a more formalized, structural, rights-based review process, one can't go back to the old traditional constitutional arrangements. Renata asks of Senior on Scandinavian constitutions about whether or not the development was through consensus. In a sense, that was what the British settlement was in the 20th century, not a strict consensus, but rather that the political conflicts were to be fought out through Parliament, because Parliament was the guardian of the Constitution, and Parliament was the institution through which these battles took place. That's disappearing. Parliament is losing its historic function as the nation assembled. And it's that disaggregation that is leading to the fragmentation that is causing anything but normalization in the British constitutional arrangement. I'll stop on that point, Marco. Thank you.
Thanks to you, Martin. Senior, your turn, please.
Yeah, thanks. I don't know. I didn't really see that either Bruce or Roberto asked any questions or contested what I was saying. So I'm not sure whether there's anything I should really respond to. I see there's some questions in the chat, but I haven't managed to read them yet. So I don't know whether this means we should just move to discussion or whether.
Okay.
Yeah.
So we can open up the floor to interventions and questions from the audience or from the other participants to the workshop.
I mean, unless I misunderstood, but I didn't hear anything specific I should respond to, but perhaps I missed some critical remarks or something.
Well, in fact, I only praised your paper, so I didn't contest anything.
I can say thank you very much in that case.
No, I mean, I just wonder whether you agree on this idea that the political process is dominating the constitutional features, and if you agree that it is more a confirmative constitutionalism than a transformative constitutionalism.
Yeah. No, I agree on both points. I mean, so on the political process, this is, I think, the strongest argument for having Scandinavia and the UK in sort of like a similar kind of grouping a system. It's centered on Parliament as sort of the heart of the constitution. I think there's a slight difference in the sense that like the Scandinavians are less adversarial. So it's really not, I mean, in the UK, this is this idea of Her Majesty's loyal opposition, right? That would never be a case in Scandinavia. It's these sort of horseshoe parliaments that are based on always consensus building. And some of the posters I had, I can perhaps share them again. I'll just show you because, can you see them?
Yes.
Yeah. So I'm just trying to have them here. So like the one in the top left quarter, this is just Danish Social Democrats, and they state their alliance at the top. So it's workers, public servants, and free farmers. So they even state that like the alliance they base it on, and then they say you have the power if you want it, like vote Social Democrats. So it's just based on this, and the same feature in the ones in the bottom right corner, and there they have like sailors as well. So it's based on this idea of like, you know, having Parliament as the engine through like winning elections all the time, but building consensus. And this broad consensus is what has been at the foundations of the Scandinavian welfare states and regimes. So my sort of my slight disagreement, perhaps, I'm just trying to unshare now. With regard to the establishment type, is perhaps that it's really not based on this extraction from an old elite, because like the aristocracy disappears really, really early in Scandinavia, and then these groups together, they actually manage to take control of the apparatus of the state, and then they drive, and that very few limitations to what they can do. So they are capable of creating a revolutionary vision, but through ordinary reform, in terms of creating a completely new society. And as a Scandinavian myself, I can say I think very few people actually understand what social democracy means outside Scandinavia, because it's not just this idea of redistribution and a welfare state. It's really about creating a new kind of human being through like a lot of different types of law, from labor law to healthcare to public education, which has to be the same for everyone, to prison reform. So it's a very comprehensive vision of how you govern, which is based off creating freedom through government. So that's the first point, but like Parliament is really the engine of that. In terms of having constitution, something that confirmative, I think that was the word you used, right, Roberto? Yeah, I mean, I think that's right in the sense that, I mean, so they're backward looking, right? They're not engines of change. So in Sweden, if you read the 1809 instrument of government next to the 1974 instrument of government, it's two completely different worlds. I mean, it's really nothing in common between these two documents, but the changes introduced were like close to zero. The real changes. They just did it to say, this is actually how we govern, to sort of to bring the norm closer to the actual form. So they call it in Swedish, it's statskicket, which means the sort of the form of the state form basically, or like the shape of the state. So it's sort of the nature of the state. So it's basically saying the written constitution should be in conformance with the actual form of government, the real form of government. But ironically, perhaps a few changes were introduced, but not on purpose when they did this reform. Yeah, so I think that's perhaps response enough to that. Yeah. So Denmark is the only case where there's been no, I mean, so the last constitutional amendment was in 1953. And when you read the Danish document, it could not be much further from like lived experience. It's this like really peculiar old document that no one really cares about. I mean, I can say that as a Dane. It's like, if you read it in high school, it's over beers as a joke. That's like how people sort of like think about the written constitution. It's not this idea of like patriotism or constitutional patriotism in any way.
Signe, there is a question from Renata. And
okay.
Bruce, Marco, and we have a question from Mike Wilkinson there. But Signe,
sure.
There's a question from Renata to you.
Thank you.
Okay, sorry.
Thank you, Mark, and thank you, Signe. This is the same thing I put in the chat. I really enjoyed the paper and also the presentation. So the question actually follows up of what you just explained about consensus politics. So is this a consequence, essentially, that because litigation is really frowned upon as a means of resolving major political disputes, like megapolitics, as Jan Herschel would call it, the constitutional text slips away because you don't drag it to court? So could the gap between the text and the practice be the result of the fact that major disagreements are played out in Parliament on the basis of consensus? And the related question to that is that in a way, ECHR definitely, but to a large extent EU law as well, forces litigation as a way of making an argument. Of course, you can hold referenda if you really want to be consequential, but the daily way of making yourself heard is bringing a case to court. And if that's so, is it a silly question? Probably it's not such a silly question to ask whether litigation before the two European courts replaced some of those functions that would otherwise be judicialized politics under a national constitution due to the consensus nature of politics in these countries.
I mean, well, I think perhaps the best way to respond to this is to say, I mean, so as is the case in UK, Parliament is a guardian of the Constitution, really. I mean, so it differs a bit, and I go into details about that in the paper, how how the different Scandinavian countries look upon judicial review. So at first in Finland, it's outright forbidden. In Denmark, it's sort of allowed, but really sort of not tolerated. But it's, I mean, so there's a formal case in the early 20th century where, you know, courts say that they can in principle review, but there's only one case in the 90s where they actually strike down a law. So it's sort of, it differs a bit, but really like the thing is that Parliament is the engine, it's the guardian of the Constitution. But the difference to the UK is that actually is a written Constitution, right? There's a written text that's, okay, it's not called the Constitution because that word is not used in Scandinavia, it's sort of called like the fundamental law. But so it's sort of, in a sense, it's less flexible because it can't just like add new laws that are sort of fundamental, because there is actually a difference between fundamental laws and ordinary laws, which is formally not the case in the UK, right? So this also means there's this like text called the Constitution, but constitutional praxis sort of just like develop, right? Like through Parliament, but not really with reference to the written text very much. So that sort of just becomes obsolete at some point because you can't really sort of renew it. You can't, and there are no principles. I mean, there are no, if you read the Danish Constitution, there's no principles, like even aspirational or ideas that will speak to us today. You know, it's just like a weird old document. So it's really difficult to mobilize around. But you know what, I'm not like pointing anything out to say there's actually a problem, because I'm not necessarily sort of, I don't have a strong opinion on whether there should be like constitutional codifications or modernizations in Scandinavia, and whether it's actually a problem. There's like a discrepancy between norm and reality, because the systems actually work rather well. I think if there's a problem, it's with regard to the status of European integration, because that has really transformed these regimes, but it's not visible. I mean, it's not acknowledged in constitutional terms in any of the written constitutions. And a lot of Norwegian scholars, so the best scholarship I would say in Scandinavia is done by the Norwegians, perhaps because they've had more formal constitutional amendments. So like the state of Danish constitutional is not as good as it could be, I would say. But anyways, they're sort of quite concerned that the actual nature of the transformations of being a member state, in this case of the EEA, are not recognized. So this means that like the integration takes place via stealth, basically through like simple majority voting in Parliament. Whereas many of these scholars agree that, you know, we should actually make it more difficult, because Norwegian people have, you know, voted in 2 referendums, so they don't want to be a part of the EU. So the question of sort of constitutional or democratic legitimacy in the sense of between like norm and reality in this sense, but I think for internal developments, it's actually not that important. And as a Dane, at least, I don't really care whether we have like a new constitution or not. It wouldn't make a huge difference to me, even as a Danish constitutional scholar. But some people will disagree on that, I think. Yeah, thanks.
Good. Okay, so now we have first Bruce, then Marco, then probably Agustin and Mike. Bruce.
Senior, what will happen if my NATO story occurs? That is to say, Putin continues to threaten Finland, and generally Scandinavia, and you will have one of 2 choices: having another referendum and going into the European Union, of course, or renegotiating NATO. You see, if we have a European army that will defend Finland, or perhaps more realistically, the other Scandinavian countries, then the European Union will then renegotiate a NATO agreement with the UK, renegotiate it with the Biden administration, who in fact will leap at this opportunity, use it as a tool for inducing Erdogan to comply with other things. And maybe there'll be a total disaster, maybe not, etc. So the fact that with the world hegemony being credible in the United States in the past, these countries have had a Scandinavian relationship with the EU. It does not follow that this will happen in the future. What is your response to that? Scary.
Well, I mean, so I think, I mean, there's some difference between the different Scandinavian countries there,
Sure.
because Denmark and Norway was firmly in the camp of the West throughout the Cold War, right? And are staunch supporters of NATO, and realize that their survival depends on the United States, right? And always pay, you know, top contribution and everything, and are very, very happy about it. So Sweden and Finland is a bit different, right? Because Finland was really a buffer zone during the Cold War, and they couldn't be a part of European integration before, after the Cold War, exactly because they remained neutral. And they managed to sort of like survive by different sort of negotiations with the communist regime. Right. So that changes, and they join European integration late for that reason. Sweden is interesting because they also remained neutral during the Cold War and only joined European integration later. But they are a bit different because it's one of the largest producers of weapons in the world, right? And they have like been quite capable of striking military alliances. But now I would say they are probably more firmly in the camp of you know, supporting NATO and relying on that. In terms of a European army, my sense would be that the support would very much depend on like bigger European powers. I think they would be very worried about what it would do, unless it was NATO backed. I think that would be like worry about it. But I mean, I think I heard a speech by the Danish ambassador to the United States a few years back, where it was at times of reflecting upon the wars in the Middle East, and he said, okay, we'll basically do whatever the United States tells us because our survival relies on American nuclear weapons. So we'll do whatever the Americans tell us to do.
So my only point, and I don't want to press it any further, is that all this was speculative. Now it isn't speculative.
Yeah, but I mean, so that's so like actually something I write about in my book is the history of the European defense community and the attempts to establish a European military federation, right? And it's been a project on the way for now 70 years, and it has always just failed, right? But I do agree with you that I think it is necessary now, perhaps more than ever. So I do agree with that, and I think it will have to be done within the next 10 years. Or 20 years at least, depending on developments. Whether there's support for it, that's another question, right? But I mean, Europe, like as a bloc, managed to survive during the Cold War because of the support of the United States. If that is withdrawn, like the game changes, right? The global power balance changes, of course.
Good, thanks, Signe. Marco, your time.
Thank you. Thank you for the paper, Signe. I have a question for you. I enjoyed the paper. My question is concerns the last part, in which you deal with the impact of European integration. It seems to me that the impact of EU membership on Scandinavian constitutional systems has mainly to do with a shift from a political constitutionalism to a right-based constitutionalism, or a constitutionalism in which there is a judicialization and judicial protection of fundamental rights. You didn't touch upon the potential, this is my question, regime change. Has European integration brought about some type of regime change? And I'm talking about, in particular, the years from the 90s, in particular the Maastricht Treaty. here we have probably a bifurcation, because we have Denmark and Sweden remaining outside the Eurozone, and that makes an important difference, and Finland, which goes inside. So I'm wondering what happened to the social democratic consensus underlying the political constitutionalism. Has that been affected, or has that remained as a pillar also within this changed context?
That's an amazing question, Marco, and I'm not going to be able to answer that fully. One thing, if I'd had more time, I did want to write about like the implications for labor law and labor law regimes, because that's obviously something that has been, highlighted by significant cases like Viking and Lavelle, right? I don't think I can give you a good enough answer now, and I'm not. Especially not with regard to the question of causality, because the social democratic consensus is starting to be weakened, at least I would say, starting in the 1990s. To what extent this has something to do with European developments and like membership in the EU, I can't answer that. I don't know. I don't know even how you would establish that. But I think so. I do. It's true. I do focus perhaps too narrowly on sort of the formal like regime change, and there the central part is that I think for the first time in the histories of the Scandinavian states, there's a written text that can be enforced really truly against parliament by courts. So this is why I call it like constitutionalism by proxy, because it's not actually the domestic constitutions that, especially in the case of Sweden, like no one cares about. In Finland is a different thing, right? And Roberto, you touch upon that. They have this, they call it the act of exception, right? So they have like a really formal, strong alliance to the constitution, but then they have this procedure where they can like make substantive changes to the constitution as long as it follows the right parliamentary procedure. So they can make, they make it hole in the wall, and then they sort of fill it with like new norms. So, I mean, clearly that's, in a sense, they're holding the constitution in high regard because they have to follow this procedure. But really, I mean, it means that they can create a new constitution, like via this mechanism, right? And that becomes much more problematic and less easy to do after European integration is introduced. So they try to limit that significantly in the case of Finland. So thank you for the question. I'm sorry I can't give you a better answer, but it's a great question.
Signe, I think we will have to insist on this because I have a question from Mike from the chat, but first I think Agustin also had a couple of questions. It will be better, Agustin, if you formulate them orally, please.
Yeah, but they are too long, so I will try to shorten them because they are too long. No, thanks a lot for the paper that finally made me understood the Norwegian constitutional pathway, which I have been exposed to repeatedly, but I could not make sense of. So that's excellent. I think you make a terrific job, not only the Norwegian, but of course the whole Scandinavian, but making it part of that, I think it makes lots of sense. My questions are, on the one hand, Mike is already invoking Meidner here, and I think that's extremely relevant. On the one hand, is it not, so to say, social democratic constitutionalism by now a bygone era in a double sense? On the one hand, what you have now is that Scandinavian countries have managed to adapt and rescue parts of the welfare state by becoming deeply capitalistic countries in terms of the external relationships. I mean, the Norwegian Petroleum Fund is as capitalist as you can get. It's turbo capitalist with a human face, all this kind of stuff. But the terms in which you are dealing with the world are not any longer that you boycott Spanish oranges because they are coming from a dictatorship or this kind of stuff. This is gone. This is gone everywhere, but also with the Scandinavian countries. And if social democracy means anything, means transcending capitalism in a reformist way and this kind of stuff, but it has to have a horizon beyond capitalism, and this is no longer there. That's my understanding. The second question has to do with what your story implies. Does it imply, and I have the long question, but in a short format. Does it imply that the Scandinavian model of, say, from the 30s to the 70s was one which proves the advantages, the primacy, the superiority of democratic politics over democratic constitutional law? So it is better to get rid of the constitution and have it only as an ornamental element? Or does it prove that the Scandinavian countries were lucky and virtuous, the two things, and they could do away without that? But the very fact that social democracy is failing by now, the fact that it could not resist the forces that were coming from what the European Union was in the 90s, proves that there is a need of thinking about democratic constitutionalism in a social democratic way, which is a different alternative, is that we need the law and we need democratic constitutions, but we need them different than what we have, say, in other countries like Germany or, whatever. We need a different paradigm. That's the question. What is what you would say is the morale that you can draw from your story? Thanks.
Okay, thank you very much, Augustin. I think I'm not so much like a drawing morale kind of scholar in general. I think this is really an attempt to understanding these regimes. I'm not so much saying which ones are superior to others. I think it's true that the Scandinavian regimes could emerge based on the very specific political and social foundations. One was the aristocracy was, it was possible to basically abolish it. And a more important one, arguably, is the status of the independent farmers, that the Social Democrats actually can go into alliance with, in that way construct majorities. So this is also why they have these like pictures of like farmers and workers together, and they were different from farmers many other places because they were well educated, they could read, and they were organized, politically organized through like cooperatives. So they could rely on that social structure to actually create that system. So I definitely, agree that you can't just like create, take the Scandinavian institutional structure and then dump it like somewhere else, and then you'll have like a new Scandinavia. It's really based on these historical foundations, and I'm not sure whether it's easy to replicate it. So I don't know really what that proves. I don't think it proves that you need written constitution or not. I think it really worked in this particular instant, and then they were capable of creating what I would judge as being possibly the most progressive and best regimes in like the history of the world. But I'm not saying that it's something you can easily sort of like construct or like engineer. I think it's more complicated than that. I'm not sure whether having a more formalized constitutional system now will in any way help in protecting social democracy. I don't really see what it would do, but perhaps you can convince me otherwise. Yeah.
Senior, can you try to have a quick go, if possible, to Mike's quite challenging question? Mike's right.
What is Mike asking?
Wait, Mike Wilkinson is asking, following Augustin's question. I will read it because I think it is quite accurate. In 1993, Swedish economist Meidner wrote an article titled "Why Did the Swedish Model Fail?" And this was 2 years before entering to the EU. So 2 years before the entry into the EU, there were already Swedish economists denouncing the decadence of the social democratic model. Can you say a little about the reasons for the decline of Scandinavian social democracy, and of course how this relates to constitutional change? This is quite a challenge.
Yeah. Oh God, I think you need someone else. Possibly like a political economist. I guess like Schuster Isbeng Andersen would be a better person to ask than me with regard to that. I really don't know. Like, why did social democracy fail? I am afraid I don't have an answer to that. If I did, I think I would probably already be in a very cushy full professor job somewhere. I think that's But I mean, it's a great question, Mike. Yeah, but I can't see you're asking a few more things actually, but I have a difficulty in like reading and answering at the same time. I don't know whether you want to add something to it, Mike, or not.
Okay, in the meantime, we can also collect other questions. I see that Bruce has another one. Bruce, do you want to have a go in the meantime?
Just one basic point. The fundamental difference between the United States and Europe at the present time is that the left is united in the United States, while the left is demoralized and disintegrated right now in Europe. Whether, and this is paradoxically the achievement of Trump, who forced all the different tendencies to unite. And right now, what Biden is saying is, we are going to have a New Deal. Well, what is that? Well, so this, whether this moment, by which I don't mean whether this 3.5-year period will generate a revitalization of some form of New Deal, which is social democracy or not, is the key question. And it is for this reason why I have been emphasizing that there is a glimmer of hope. If the Europeans somehow, social democrats on the European level, somehow engage in a project with Biden that will actually succeed in supporting the reconstruction of the New Deal at home in the United States in a way that also supports the revitalization of the left in Europe. Whether the defense thing or some other thing is the best way of doing that, that's an institutional strategic question. But this is the possibility of the Biden presidency and its successor if we manage to beat Trump a second time.
Good. Is there any other question? Also from the audience, of course.
Marco, in the chat box.
Yeah. Yes.
Augustine raised the question. I don't think it was for me, but he raised the question of whether it was possible to have a negative judgment on Brexit and to characterize the settlement negotiated by Cameron as sensible. I'm not sure I entirely understand the question, but I think the answer is no. That is to say, what David Cameron did in 2016 was to go to the European Commission and Council and negotiate an opt-out out of ever closer union. And having negotiated an opt-out of Britain having to sign up to ever closer union, he then came back to the British people and asked them to ratify their membership of an association devoted to an ever closer union. It was totally irrational. It wasn't surprising. I mean, there were lots of other factors, but it wasn't surprising that that wasn't a very convincing position for him to hold. That's the only point I would make about that. I can say something about some of the other matters, but I will not at the moment.
Let me read the second question by Mike Wilkinson, who might actually be of relevance for all the panelists. I mean, so taking the cue from Ackerman saying that he rejected the label constitutionalist for the Scandinavian model, pre-EU, because there were no institutionalized constraints on parliament. What does institutionalized mean here? Couldn't institutional restraints be those placed by, for example, trade unions? In which case, why not call it constitutionalist? Is this just definitional, or does it claim to make a deeper point? I mean, perhaps Bruce and also Martin and Signe, they want to, and Roberto as well, they want to address this. And then I will also read Borja Garic's question.
Sure. You see, when we say trade union, we could mean one of two things. There is an institutionalization of the state, which says that there shall be a second chamber in which trade unions would be have 42 seats. This is, if you go back to the Holmes-Lasky correspondence, things like that were in fact very seriously considered in the UK. This is the institutionalization of unions within the structure of the system of government. For example, I'm presently advising the Constituent Assembly in Chile, which has just been elected, and there are 17 members of the indigenous tribes. And one of the central issues of the Constitution will be, how will their interests be expressed within the system? And there will be some kind, the solution will be some kind of institution of check and balance, or veto and override, or something of that kind. If, however, one is simply talking about power politics, we have the trade unions on the one hand and the corporations on the other, and they are trying to influence the institutions of government. Of course, that is a part of the analysis that I am not, in the spirit of Signe, trying to, this is not what this project is about. How does the voters, coalitions, individual civil society organizations, not voters, forget, voters are part of the system, individual civil society organizations, big business, international capital, all of these, how do they influence Sweden? This is a very important question, but it isn't the question of how to organize the system of democratic will formation.
I have a slightly different response, because actually sort of in Scandinavia, I can give the example of Denmark I know best. There is what we could call a labor constitution that was created by a compromise in the interwar period, where, so it's not a formal institutional process in the sense it's not representative, but wages are negotiated between labor and capital and the state in what they call a three-partite negotiation. And this has been a stable part and is part of the foundations of the regime. And it's been that for almost 100 years now. So I think this is sort of something that I would argue should actually be included in your analysis, because it's not just power, it's actually part of the foundations of a regime. And it is a legal institution that was created. And there's similar things, I know the name for the Danish one, but there's similar ones in Sweden and Norway, I know, that was struck. And this is the foundation, just not just the social foundations, but also the political foundations of the regime.
That's right.
And
so that's the question of how do we define the concept of institutionalization? What you're describing is the same system established by the National Labor Relations Act, which has been assaulted and undermined. However, the system is the workers in a firm have a vote. And if a majority say we want to have a union represent us in the bargaining on the wages, the employers cannot, we have a right to strike, and the employers cannot replace the employees. The employers have to bargain in good faith, and the National Labor Relations Board and its institutions will sanction employers who refuse to. Now, this still exists as a system on the books, which has been destroyed, in fact, by the forces of international and national capitalism. However, so what counts as an institution is a question of internal legal interpretation. So I don't think we're disagreeing. It's rather in the Martin Wolfman spirit, how things get institutionalized within the structure of government depends upon the legal understandings of the internal system in one place or another.
And I think this is like the strength of the regime approach, and I really agree. So like I would say like a central part of the material constitutions of the Scandinavian regimes is the way labor law is structured. But that also, I guess, in response to Augustine's point earlier, I mean, as soon as you put that into a formalized constitutional system or like structure where it's like adjudicated by a court, that will in itself change that balance, right? Because it will change the nature of how you actually.
It isn't in the US adjudicated by a court, it's adjudicated by a special labor board of 5 members who are selected in a way so as to ensure a bipartisanship.
No, I mean, there are labor courts in Denmark as well. And this, the reason I flagged this was in relation to the European the question of how you actually relate between then the domestic level and the EU level, because the way it works in the EU, that would be adjudicated by like Supreme Courts. So that would change the question of how do you protect then the constitutional system, which is not formalized in a constitutional text. And you can't really protect it that way, because in itself that would change the nature of the whole system. If you try to protect, then you would have a better route. And I think this is what they have tried to do, is to sort of acknowledge the special status of how labor law works and try to protect it. But we have had the cases of Viking and Laval that have in large part sort of, and this is what Marco Dania asked to, right? The question of things like, how has labor law been changed? And I'm not a labor lawyer myself, so someone else will be more competent to speak to that. But it's definitely an interesting and important question. And goes to Mike's point as well in terms of, I think like the way I would say it in terms of constitutionalist, I think I was more talking in Martin terms here, in terms of somehow distinguishing between constitutional government and constitutionalism as sort of a different things. And it would definitely not be constitutionalist, but it is a central part of the Scandinavian constitutional regime structures or constitutional governments, if that helps.
As I said, I'll try to address Martin's point a little bit more elaborately next time, but I don't want to.
Martin, do you have any reaction to this last point?
It's just that Mike's question brings us back to the complexities of comparative method. If we're talking about institutions, well, institutionalization, the patterns of institutionalization vary tremendously from one regime to another. But it's not just institutions, it's also cultures. And that whole literature, the whole debate rather, takes us back to the literature of the early 20th century, as Bruce mentioned. It's the literature of Santi Romano and institutional orders. As you know, Bruce rightly said, well, the Webbs wrote in 1920 a constitution of the Socialist Commonwealth of Great Britain, which had a second chamber that was a functional parliament that had the representation of trade unions and workers and employers in that functional assembly. This is a different world to the world in which we are living, and I don't understand, if one takes a regime analysis, how comparative constitutional law differs from comparative government.
Well, as I said, I'll try to answer that, Martin, tomorrow.
Oh,
but to keep you here. But on the crucial question, notice what this discussion and what this book is intended to do is to say you're absolutely right. There should be 500 scholars in comparative constitutionalism in the next generation, and this is not a task. You know, whatever you want to say about my effort, this book is not aimed to be a final solution, but rather to open up an agenda for the next generation, so that which can study how the Eastminster systems of India are similar and different from Canada. Have 3 people do that. That would be great. That kind of thing. It isn't that one single mind could ever hope to do anything other than encourage a conversation, which happily is already occurring. This is one of the most dynamic fields of law right now that I could point to. There are many more people in doing this than in labor law. Alas.
The question I think I would want to ask you is, can one develop a sufficiently robust but flexible conceptual vocabulary through which we can embrace these differences?
Completely right.
Or are we going to talk about, going to talk in different registers and different regimes? That's the big challenge.
And that's my 3 paths, and maybe there should be 5 paths, and they should be different. Fine.
Oh, we are running out of time. Actually, we already run out of time. There is only a few seconds to address Bojan Vugaric's question, which is basically a way to probe the prophetic skills of Bruce Ackerman. He is asking, and Bruce, you won't have much time to address this, so please basically say yes or no. Jack Bolkin, in his cycles, is very optimistic and predicts a new cycle of progressive constitutional time in the US after Trump. Would you agree?
I think he's too optimistic. He is applying David Mayhew, Steve Skoranik's scheme, but in a way that is plausible but not compelling. It may well be that in 2024 we will have not Trump but someone worse than Trump. Hawley is the fellow's name, who is as nationalistic and unilateralist as Trump, but has the other feature that he can think.
Okay.
This would be the beginning of the end of American constitutionalism. And we don't know what's going to happen.
Good. You are less optimistic.
Happy note.
So thanks in particular to our panelists. Thanks to Martin, thanks to Signe, thanks to Roberto, and thanks obviously to Bruce, and thanks to everyone in the audience. We will see again. We'll meet again tomorrow. We will have 3 engaging case studies, which are supposed to test the elite pathway, Germany, Hungary, and Spain. So I hope I will see you all tomorrow. Stay safe.